Good afternoon, everyone. I would like to welcome you to our webinar on mental health law, which is hosted by METRAC. My name is Andrea Collins Fitzpatrick, and I am the Legal Director for METRAC's Community Justice Program. I would like to begin with a land acknowledgement. Although we may all be located in different places right now, I will acknowledge the territory in which METRAC is physically located. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only and is not legal advice. The information provided is not intended to be used as legal advice for a specific legal problem. Please note that this webinar will be recorded and will be posted on our website at onefamilylaw.ca. I would also like to remind you that we will have a Q&A after the presentation. If you have any questions, please post them in the chat. We also have a survey that we would please like you to fill out. It will be posted in the chat towards the end of the presentation. Before I hand it over to Charlena, I would just like to tell you a little bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women FLU series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website again at onefamilylaw.ca for more information on your family law matters. I'm delighted today to have Charlena Claxton to speak with us about mental health law. Charlena has been practicing law in Ontario since 2005. She was called to the Nova Scotia and Ontario bars. Charlena practices in the areas of criminal law, mental health law, and civil litigation. She's the president of the board of directors at Dr. Roz's Healing Place. Welcome, Charlena, and I'll now pass things over to you. Thank you so much for being here today.
Oh, thank you so much, everyone, for inviting me. It is a pleasure to virtually interact with everyone, which is, you know, one lesson learned from 2022 is how resilient we all are in terms of transferring our in-person interactions, conferences, and seminars to online learning. In terms of my experience, I practice in primarily mental health law, which comprises of both civil, criminal law, as well as consent and capacity board work. I am hoping that at the end of this seminar today, that everyone takes a little bit something from it and understands exactly what are the various aspects of mental health law in the Canadian system, and specifically Ontario. I'm licensed to practice in Ontario, and my information is going to be geared to Ontario residents and Ontario laws, and we'll go into that. But the specific topics that we're going to cover. First, introduction in terms of what is mental health law. I'm going to go into the various aspects. The first one that I'll cover is the Consent and Capacity Board. What is it? How does one find themselves in front of it? Whether or not you have a capacity to consent to treatment versus a power of attorney issue, which I'll also discuss. How someone becomes an involuntary patient. And then I'll highlight a little bit on not criminally responsible with one case to review, and that is in the criminal context. The information that I'm providing you is going to be accurate to today's date, but nothing that I say is legal advice. Things change, and much of what I'm going to say are broad generalizations. There are specifics with any issue. So first, if we go to introduction into mental health law. So mental health law can comprise of various things, but really we're talking about a legal system where we're looking at how are we going to restore one's mental health and navigate the legal system while we're in it. There are various regulatory environments, tribunals and courts that are specific depending on what it is that the issue that one is grappling with and how to resolve or address any common concerns. I provided in the PowerPoint a quote, and that is from the Jennifer A. and al. Law and the Mind Mental Health Law and Policy in Canada, which says, while the legal system cannot by itself achieve the ultimate goal of restoring mental health, the legal system can create a social and regulatory environment that assists medical professionals in delivering their services in a manner that is both ethical and respectful of the rights and needs of persons with mental illness. So when we go to the Consent and Capacity Board, and before anybody reads that slide, there are really three major ways in which one's mental health can be addressed through the court system. The Consent and Capacity Board is a tribunal, so it is not a court. The persons that make decisions are appointed, and there are different acts that govern the decisions that they're able to make and how they're going to make it. It is for individuals where a psychiatrist, for the most part, not all, but a psychiatrist has found that a person is incapable of either consenting to their treatment, incapable of managing their property or their finances, or involuntary and should be admitted into a psychiatric facility for monitoring, treatment, and care. There's also another avenue, which is called a community treatment order. That is another way for somebody who is not in hospital, but is governed, their ability to make their decisions about their treatment or their living arrangements or their interactions with mental health professionals can be guided by an order by this tribunal. When we go to a Consent and Capacity Board hearing, we have the tribunal, which we call as the panel. Most cases that come before the panel involve three individuals that are going to make a decision about whatever issue is before them. Sometimes it's one person, but most often it's three. There is one person, a chairperson, who has a legal background and is a lawyer member panel, one person who is a psychiatrist member on the panel, and one person that's neither a psychiatrist or a lawyer and is appointed as a community member. Those three individuals are independent of the patient or the client, independent of the hospitals or the doctors, and independent from the lawyers. The rights advisor is usually a first contact for an individual that has concerns about their ability to make their decisions or where the issue is being raised. A rights advisor will meet with the person and determine, one, if they are in hospital, whether or not they are okay with being in hospital and they agree with the psychiatrist's finding or with the finding of being able to manage their property, or if they wish to proceed and be under the guides of a community treatment order. They meet with the rights advisor, and the rights advisor will essentially say, you have some rights. You can agree to what the psychiatrist findings are, or you can contest it. And if they contest it, the patient or the client makes an application to the tribunal to have their matter heard. The psychiatrist that deemed the person either incapable of consenting to their treatment or unable to manage their finances are present at the hearing. The lawyer is contacted, usually by the rights advisor, sometimes by the patient or client themselves, to represent the person before the board. And the proceedings are recorded and the decisions are made. And generally speaking, decisions are available on the Consent and Capacity Board website, as well as other research avenues. Legal Aid Ontario is available to finance and to pay for lawyers who represent the patients, and the patient just has to qualify based on financial incapabilities. And if you go onto the Legal Aid Ontario website, you'll see what the financial qualifications are. You cannot make an excessive amount of money. And generally speaking, we're looking at the most vulnerable persons. We're looking at persons whose capacity or freedoms are at risk. And if qualified for Legal Aid Ontario certificate, have difficulties or are deemed to have difficulties in paying and retaining a lawyer, so they are entitled to have one that is under their panel. Should somebody not have a certificate, then they most likely are paying their lawyer privately. Those are the participants in consent and capacity board hearings. Those three areas, excluding the community treatment order, are common types that come before the consent and capacity board. Capacity to consent to treatment is generally as a result a person has been deemed by a psychiatrist that they're unable to understand information that is being provided to them and unable to appreciate the nature and consequences of the decisions that they're being asked to make. If you do see that there is somebody who is struggling in terms of antipsychotic medications, has symptoms of mental health illnesses, and are having difficulty determining which medications are required or are necessary, if there is a psychiatrist that does an assessment and there's varying forms that need to be completed as to their capacity, if that psychiatrist deems that that person is incapable of consenting to treatment, they are issued a form, and then we go through the process of coming before the consent and capacity board. The issues before the consent and capacity board is different than a power of attorney. If anyone is familiar with having a will and a power of attorney, where if you become incapable, then the power of attorney may come into place and you have your decision makers for particularized purposes, is one way of doing it. But what is happening for capacity to consent to treatment, that is for most of the time someone who does not have a power of attorney, and it's specific to those with symptoms of mental health symptoms and requiring some form of medication against their will. Similarly, the second area is capacity to manage finances. That is not a power of attorney over finances. It's something, if someone has a power of attorney over finances, generally they cannot be found before the consent and capacity board. This is where a person may be splurging their money because they believe they have inappropriately defined reasons for spending their money, attached to, again, the same test, which is the capacity to consent to manage their finances, ability to understand the information that's being provided to them, and their ability to understand the decision that they're being asked to make. The third area that comes before the consent and capacity board is an involuntary admission to a psychiatric facility. That involuntary admission, if somebody is brought, sometimes it's family members that go to a justice of the peace and say a family member or a friend of mine is not well and is harming themselves, harming others, can potentially harm other people, or can potentially harm themselves, or are deteriorating such that they need to be hospitalized. The justice of the peace or a judge can issue a form to have police have that person brought to hospital. Sometimes the police bring an individual to hospital under a form because they have particularized concerns. Once that person is in hospital as an involuntary patient, the code requires that an assessment happen within 72 hours. There's other steps as well by a psychiatrist to determine whether or not any of the grounds for involuntary admission are met. If the psychiatrist deems that the person is involuntary, the rights advisor will give advice, and then the person will thereafter determine whether or not they're going to accept the involuntary status or contest it, and then we go back. If they're contesting, then it generally goes before the consent and capacity board. So that's one avenue in terms of mental health in the legal system. The second avenue are mental health courts. So while the consent and capacity board is a tribunal, the mental health courts happen in court settings. I was going to say at the courthouse, but generally since the COVID pandemic has started, a lot of the courts have become virtual. So now it's both in-person and virtual, hybrid nature. Mental health courts, if someone is charged with a criminal offense and are facing charges, they may find themselves before a mental health court for various reasons, and it depends on which courthouse and which jurisdiction and what the specific issue is. In Ontario, there's approximately 60 specialized criminal courts. And those include drug treatment courts, community treatment courts, integrated domestic violence courts, and along with the mental health courts. I'll focus on mental health courts for the purposes of this seminar, but they all have varying similarities. The first mental health court was pioneered in Toronto, and it was set up, what was noted in the Globe and Mail in 2018, as being a solution to a vexing problem of mentally ill offenders. At that time, between 25 to 30% of people who languish untreated and inadequately treated were found behind bars. I could not find any more recent percentages of those that suffer from mental health symptoms, are charged with criminal offenses, found themselves awaiting bail, incarcerated, or in detention centers across Ontario. But I suspect that the pandemic did not assist, given the rising numbers of persons that we are seeing on a day-to-day basis. When one is found with charges before the court, that means that they have a presumption of innocence first. But also, it sometimes raises the question as to whether or not the person is able to navigate the legal system. Mental health courts are generally geared for lower level charges. All charges are serious, all offenses are very serious, but it is meant for persons where the charges can be addressed through sometimes alternative means, but it's a hub. It really is a hub, a community hub, which in the courthouses that have them, of mental health professionals, caseworkers, program providers, lawyers, the Crown attorneys, and the judges all have a heightened awareness in terms of what is being faced before them today. Sometimes community treatment plans are developed as part of the appearing in the mental health courts, and that plan goes towards rehabilitating the individual, addressing the offending behavior, and hopefully to reduce the recidivism that had often found its way without courts of similar natures. If we can go to the next slide, this is a fact scenario in terms of what we may see at the mental health courts. This is from a master's paper that I wrote that looked at whether or not the lack of mental health courts in certain jurisdictions provide unfairness to accused that are before them. But this fact scenario, Stacey is charged with an assault on nursing staff while she's an inpatient at a psychiatric facility. Stacey has been charged with assault pursuant to the provisions of the criminal code. The Crown attorney, who's, in the United States, we call them prosecutors, have screened this plea position for 6 months custody. Stacey is brought into custody and appears in bail court and is presenting symptoms of a mental illness or disorder. She has a history of violent behavior, and bail without upfront treatment is not likely. She appears unfit to stand trial. And I'll stop there before I continue. Unfit to stand trial is also defined under the criminal code. And to summarize, it's somebody who is unable to understand the proceedings, are unable to instruct counsel. A person that is unfit to stand trial at that time, it could be fluid, but at the time when an assessment is ordered, there are concerns that their fitness is at issue. Then the person has a fitness assessment. And depending on the results of that fitness assessment, if the person is unfit to stand trial, then the criminal process in and of itself is paused. And the person goes to a different system to address their fitness. And when they become fit again after treatment, often forced, they return back to the criminal court system. So my fact scenario I want to work on is what happens when the person is fit, but is unwell. They have their bail hearing, but Stacey in this circumstance is languishing in jail and her mental health is deteriorating. We can look at that fact scenario and determine the Crown attorneys and the lawyers are often involved as well as the judges to determine whether or not someone can benefit from mental health court, mental health services, and a plan for release that is guided. Because not all courthouses have mental health courts, the services that can be available to a person differs from jurisdiction to jurisdiction. But where there is a mental health court, we find that they are able to at least have the resources available, or I found that they have the resources available to them on a quicker basis, or faster basis, I should say. And bail plans can be fashioned in a faster way. There are similar factors of mental health courts that help persons like Stacy. And if we could go to the next slide. All mental health courts accused are handled in a single court docket, meaning it's one court, one group. There is a collaborative team that is used that links treatments with supports in the community. There is some assurances, more assurances of availability of appropriate clinical placements prior to a judge making or ruling on a case, because they often have on-site psychiatrists, or at least psychiatrists that can be tapped into quickly. And specialized courts, their monitoring is used to avoid possible non-compliance with sanctions. So, for example, if somebody is of no fixed address and is struggling to get to court, mental health courts and the treatment team and the persons and the community resources may help and engage the person such that the non-compliance with bail terms can be met. The types of proceedings in mental health courts are similar to all regular courts as well as other specialized courts. I have not seen too many trials. In fact, I don't know if I've seen or heard of a trial in a mental health court, but generally bail hearings, we talked about fitnesses to stand trial, not criminally responsible treatment orders, are all things that are routinely found in the mental health court system. Being fit to stand trial is of paramount importance because we don't want to convict somebody and have them subjected to a criminal record or a finding of guilt without them being able to understand what is happening around them and make a proper decision about the court process, the trial process, their understanding of the various pleas that one can enter, meaning guilty or not guilty. Well, you don't enter a plea of not guilty, you're presumed innocent and found guilty after a guilty plea or a trial. But one needs to understand the process and at least even able to understand and instruct their lawyer. The unfit to stand trial, the test, understand the nature and object of proceedings, possible consequences of the proceedings, and or communicate with counsel. When one is unfit to stand trial, then they go generally to a psychiatric facility pursuant to a treatment order. If the psychiatrist feels that a treatment order is warranted because they think that the person will become fit to stand trial with treatment. All of the proceedings, whether it's before the Consent and Capacity Board, regular court streams without a mental health focus, or the mental health courts, are all guided by statute and case law. And these are really very, very bare bones in terms of what we may find. The next section that we have, and I do want to first note to everybody that I'm about to speak about not criminally responsible and what does that mean. And I'm going to be referencing the Manassian case. That's a 2021 case that came out, and it involves Mr. Manassian, or as the judge had written in the case, Mr. Doe, was found to be criminally responsible for his actions, notwithstanding the defense counsel's presentation or defense that he was not criminally responsible as a result of a mental disorder. And in this particular case, it was autism. So I want everyone to know that this part may be triggering. It involves the Young Street murders, and I want to give the proper warning before I continue. So, one who's not criminally responsible. I must get this question quite often when this issue, or these three words, which means so much in case law and in the criminal justice system. Being not criminally responsible, before we get to the section under the code. First, you have a person that's charged with criminal offenses. Then you have a finding of guilt, whether it's because the person pleads guilty or after trial is found guilty. And what they are saying is, I should not be and I'm putting it in general terms, it's not that I'm not responsible for the act. It's that I'm not criminally responsible. And I'm not criminally responsible because at the time that I commissioned the offense, I had a mental disorder that rendered me incapable of appreciating the nature and quality of an act, or that I rendered me incapable of knowing that it was wrong. And those two sentences, Part A and Part B of the Criminal Code, Section 16, have been litigated and dissected hundreds of times. But what did it mean in this case? What does it mean generally? I often say it's a really difficult test to make. It is also not somebody who is found not criminally responsible. It doesn't mean that there's no repercussions for the person. It doesn't mean that they get off scot-free. It just means that at the time that they were unable or incapable of appreciating the nature and quality of the act. For example, one was an act of violence occurred because they misunderstood the danger that wasn't present. Maybe they were hearing voices, maybe they were seeing things, maybe they had auditory or visual hallucinations. And those auditory and visual hallucinations was as a result of a mental disorder. And mental disorder has also been defined and litigated a number of times, particularly in this case. If one, for example, consumes illicit substances voluntarily and without any other factors involved and commit an offense, in my opinion, not necessarily in my opinion, the not criminally responsible would not meet the mental disorder factor. But if the person was consuming substances because those substances masked, reduced, or were a subset of a mental disorder, then it may. If somebody has committed an act and at the time of the act, they were incapable of appreciating the nature and quality of this act, they were incapable of knowing that it was wrong. For example, and I'm just generalizing, they thought that they were under threat from persons that were not actually visually or actually there. And so they lashed out. They were unable to understand that they did not have a threat. They did not know that they were wrong in defending themselves. So in the Manassian case, I put in paragraphs Mr. Doe, and if you look at the case itself, the judge was very specific in making sure that Mr. Manassian wasn't going to, was very specific in using the Mr. Doe as an alias. The experts in that case, because it was an autism spectrum disorder case, they found that he was not psychotic at the time of the attack, nor was he suffering from any delusions. They thought, the experts, according to the case, that he was fully aware of what he was doing when he was driving down the sidewalk and caused the deaths of so many individuals on Yonge Street. It's not that he was psychotic at the time, it's that he did not know that what he was doing was legally wrong. And that was really the only issue before the court at that time. It was whether, because of his ASD, he was incapable of knowing that his actions were morally wrong. On this issue, the experts that were presented at the case differed. So what was interesting about this case and what made it novel was it is one of the few, if not the very first, case that has concluded that ASD meets that first threshold. Before that, it was very difficult for someone to have autism spectrum disorder, commit a criminal offense, and then be eligible or be successful, I should say, in having a not criminally responsible finding. This case opens up that door for the possibility of that happening. For those that interact with those that come through the criminal justice system, it really is a turning point that we all definitely appreciate. Mr. Manassian himself was not successful in being found not criminally responsible, and therefore was convicted under the criminal code for his charges. But this case was helpful in that one day a case may come where it is available for persons with ASD to benefit from an NCR finding. Panel number 24, the Section 16 defense has not been established, and the judge finds John Doe guilty on all counts on the indictment. And decisions and reasons for sentencing followed. What lessons have we learned from 2022? Really, what lessons have we learned since 2020? The systems that I've described, the Consent and Capacity Board, the criminal court system, as well as the mental health courts within the criminal court system, have all now started working remotely. The Consent and Capacity Board are entirely remote. It used to be that hearings were at the hospitals mostly, or in the community at the facility, which is connected to the patient. And now they're conducted by Zoom. Criminal courts, for the most part, remain virtual. Almost all are hybrid in nature. But what we didn't foresee when we moved towards this is the most vulnerable of persons, the most vulnerable of our populations, are struggling with the lack of connections and the inability to really navigate a very privileged world virtually. When I had written my paper about mental health courts and fairness, at that time, which was pre-pandemic, slightly before pre-pandemic, I had found that those courts that did not have a mental health specific court versus those that did, persons were treated differently. There were less services available. There was less autonomy and more recidivism when they came before courts that didn't have it. I only suspect, and I think it's quite an educated guess, that the increased difficulties in connecting with individuals that are often felt in the private sectors, in your communities, with your population, are also equally felt through the justice system or the legal systems, because the most vulnerable don't have access, and the most vulnerable find themselves navigating a system that is very difficult for anybody who is privileged to have electronic devices and access and resources. So that said, there are some mental health resources that are listed in the PowerPoint presentation, and there are a number of others that are available to the service providers as well as the clients that everybody services. I ask that everyone look at those resources. There may be a need for someone somewhere to use those. And that said, I really do want to thank everybody for allowing me to speak. If there's any questions or any comments, please feel free. I threw a lot of things in there, and I went as fast as I could within the hour that we have. But I hope some of the, oh yes, Estella.
Hi, Charlene.
Hello.
How are you doing?
Good.
That's great. My question is, when usually the person who has been charged goes to the health facility, they committed an offense. At the time they committed the offense, they were not on their meds, right? They commit an offense, they get into court, they say they don't have the capacity. They go into a health facility and they're taken care of, and then they're told that now you're good to go, and they're returned to face the charges. Those times are really tricky for the community because there's no understanding of what happened there in between that time. Also, my question is, what happens if that person actually gets off the medication again and has no capacity? Like, if it's the medication that gave him the capacity, but at that time they're facing the charges, but they're no longer taking the medication, so they've regressed. What happens in those cases?
Yeah, so if one is found, and what you're speaking of is if somebody's found unfit and is now treated, then they get returned to the criminal court system. Once they deal with their criminal matters, then that ends that part. So they may have a probation terms to, maintain contact with the probation officer and seek any counseling or treatment as they recommend. But generally speaking, that ends that criminal court process. So if they do deteriorate and then they find themselves before the criminal court system, then that cycle continues. And that's the recidivism that I was talking about. Unfortunately, the criminal court system, generally, in my opinion, is not the place to treat individuals. The tools available at the criminal courts is limited. We can determine whether someone's fit to stand trial. We can determine whether they're not criminally responsible. But like families call me and say, he's in jail and I want a judge to order an assessment, or I want the judge to order treatment, or, this didn't happen because of this. And everyone's hands are tied. Because a judge can't say, okay, well, we're ordering you treatment unless the person's unfit. So the cycle may continue. It may get to a point where the person was so unwell at the time of the offense that they instructed their lawyer to bring a not criminally responsible assessment and see if they can be deemed NCR. But I can't act without those instructions. And there's different levels of tests that the Crown has to meet in order for them to bring it without consent, or even a judge to raise it. I hope I answered the question. Are there any other questions? Well, I really do hope it was helpful. I really do. Thank you for inviting me to speak today. Thank you all who came and listened and participated and asked questions. And I hope to see everybody soon. I really prefer in person. I know the convenience of being virtual is very strong, but until next time, at least from now.